to everybody. And thank you to one of our members who so graciously gave us treats because we were so rudely interrupted with his phone one day, not pointing fingers, but he gave us extra great treats. So thank you. Committee, today we're going to have the hearing on House Bill 2755. And then we're going to work 4 bills at the end. And I think we'll have time. Just again, welcome to House Judiciary on February 14th. And we're going to go ahead and open the hearing on 2755. And we will call on Natalie, our reviser, to give us an overview.
Thank you, Madam Chair. 2755 requires compensated sureties who post bond in municipal court to comply with certain requirements. It requires a minimum bond premium in district court and provides reasons for suspending or terminating the authorization of a compensated surety. Section 1 amends KSA 124301. That's the section relating to appearance bonds in municipal court. Current law there in subsection A requires the municipal judge to set an amount for an appearance bond. This bill would require the amount to be the same regardless of the method used to secure the appearance of the accused person. Subsection B lists the available methods of securing the appearance of an accused person, and this bill would add the execution of an appearance bond by a compensated surety to those available methods. Section 2 amends KSA 22-2809B relating to the requirements for compensated sureties. The bill amends the definition of a compensated surety to only apply if the surety posts bail for 4 or more persons in a calendar year. The bill also adds the definitions of appearance bond premium, which means a fee charged by a compensated surety for posting an appearance bond. New subsection B4 is added to provide that the chief judge in a judicial district may require a compensated surety to submit to a state and national criminal history record check as part of an initial or continued authorization to act in a judicial district. Subsection C is amended to clarify that the current law requirement that property sureties shall not be allowed outstanding appearance bonds that exceed an aggregate amount, which is 15 times the valuation of the property described, only applies to outstanding appearance bonds in the state of Kansas. Subsection D is added to provide that a compensated surety is required to charge a minimum premium bond, a minimum appearance bond premium of 10% of the face amount of the appearance bond. In paragraph 2, only post a bond after the surety has received at least half of that required minimum appearance bond premium. That bond premium can be paid in U.S. currency, a check, credit or debit card transaction, or a bank or wire transfer. And 3, that bonds, that compensated surety has to be physically present when the bond is posted and sign the bond at the jail. Subsection D2 there provides that a compensated surety may enter into a premium financing agreement for an appearance bond premium amount that exceeds 10% of the face amount of the appearance bond. And I would note here that I, in drafting this bill, I made a technical error. So I'll probably be bringing you a technical amendment if this bill were to be worked to bring it into compliance with what the requesters asked to be in the bill. And I think that Katie's testimony might allude to that too as well. So subsection F is amended to provide a non-exhaustive list of reasons for terminating or suspending a compensated surety's authorization in a judicial district. Those reasons would include filing a false statement, soliciting appearance bond services at a jail, failing to charge the minimum appearance bond premium, paying a fee or rebate to those who have the power to arrest or secure settlement, compromise, remission or reduction of an amount of an appearance bond, paying a fee or rebate for information relating to apprehension of fugitives to an inmate in exchange for a business referral, requiring or accepting a thing of value from a principal other than an appearance bond premium, intentionally failing to promptly return collateral to a principal when the principal is entitled to that, knowingly employing a person who has been convicted of a felony unless that conviction has been expunged, or failing to pay any forfeiture judgment within 30 days of the filing of the journal entry of judgment. A provision is also added there to allow the judge or judge's designee to investigate claims of violations. And if the chief judge makes a finding that a violation has occurred, then that chief judge can suspend or terminate authorization for that compensated surety to act in the judicial district. Subsection G relates to the continuing education. It's amended to change the cap on the fee charged for continuing education by the Kansas Bail Agents Association from $250 to $300 annually for those 8 hours required. It also provides that the cost of that class that's less than 8 hours can be prorated based on the hours. And I can take any questions.
Okay, thank you so much. Committee, do we have any questions for Natalie? Representative Mon?
Thank you, Madam Chair. Natalie, you referenced bonding in municipal court, but this isn't just limited to municipal court. It
No.
applies to district courts as well.
Yes, Madam Chair. So the first set of changes I talked about, you'll see in the bill, Section 1 amends 124301, and that in that case we're talking about bonds in municipal courts, and those changes are just that the amount has to be the same regardless of how you're securing the appearance. And the second change there is that one of the methods for securing the appearance is by using a compensated surety. The rest of the changes apply to compensated sureties in district court
And municipal court, right?
Yeah, I mean, some of them would be. I'm not sure, for example, like the authorization to act in municipal court. The bill does require that you be in compliance with those, but I'm not sure that they would fingerprint. So I'm not sure that requirement would apply in municipal court, but otherwise, I mean, they would have to be in compliance with the Compensated Surety Act in order to act as a compensated surety in municipal court.
Thank you.
Committee, are there any other questions? Okay, seeing none. Natalie, thank you. Really appreciate that. Okay, we will go ahead with our proponent testimony now. Katie Wisman on behalf of the Kansas Bail Agents Association. Welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Katie Wisman, and I'm happy to appear on behalf of the Bail Agents Association today as a proponent to House Bill 2755, which, as Natalie summarized, proposes some important changes to the statutes which govern appearance bonds in Kansas. So before I kind of highlight the key changes in the bill, I'd like to start with just a high-level overview of bail bonds and the important role that they play in the criminal justice system. Fundamentally, bonds help secure a defendant's appearance in court while still allowing them to remain outside custody pending trial. So in some cases, a judge will set an OR or a PR bond, which essentially is the defendant's promise to the judge to return for court. In other cases, the judge will set a cash bail amount. And in these cases, a defendant can secure their release pre-trial by utilizing a third party. So for instance, a bail bondsman who will provide a financial guarantee to the court on behalf of that defendant. So at a very fundamental level, that's kind of how bonds work. So for those reasons, access to pretrial release and still securing the appearance in court, bail bonds play a really critical and fundamental role in the Kansas criminal justice system as well by providing that defendant access to pretrial release while still guaranteeing, or at the best of their ability, their participation in the judicial process. So it's actually the judges that are responsible for setting those cash bail amounts in an amount that's commensurate with the severity of the crime, the criminal history of the defendant, the flight risk that they pose, and their access to financial resources as examples of some of the considerations. So in a whole, the entire system really works to balance the rights of the defendant with our personal and communal interests in safe communities. So the bill that you have before you proposes not to disrupt that balance, but to try to reinforce it. There have been a number of instances in the past year where the practice of offering discount bonds to defendants accused of some pretty egregious person felonies has led to some pretty significant public safety concerns in Kansas communities. And I imagine that you'll hear more about those particular instances from some of our law enforcement partners. So even if that practice of offering discount bonds is well-intentioned, It threatens not only the safety of our communities, but also the integrity and livelihood of the bail industry itself. So for those reasons, the Kansas Bail Agents Association felt that it was important to proactively get together and have discussions about and propose a balanced solution to address those aforementioned concerns. So kind of in a nutshell, what we believe House Bill 2755 does is include some common sense recommendations that accomplish things kind of in three buckets. First, it addresses that practice of discount bail and the underlying, or well, the public safety concerns that that creates. It ensures that defendants continue to have a constitutional right to surety bail and that those rights are honored. And it continues to enhance the professionalism of the bail industry in Kansas. So the specifics of those changes, I'm going to let the next conferee get into and explain a little bit more. And before I wrap up, I did want to call your attention to my written testimony that does acknowledge some recommendations for amendments. Most of which are the result of continued conversations with stakeholders. So we would be happy to work with those stakeholders and the revisor to draft those amendments. One of which I might just mention here real quick, that Natalie addressed as a technical thing, but I think it's important as you read the bill. On page 5 in lines 20 through 22, we would propose to strike that a compensated surety may enter into a financing agreement and say that they shall enter into a financing agreement for any unpaid minimum. And again, Shane will get into some more detail on that. But really, at the end of the day, I want to reiterate our support for House Bill 2755, which really seeks to strike a balance between individual liberties and public safety, between the criminal justice system and the professional bail bond industry. We would hope that the committee would recommend the bill favorably for passage, and I'll be happy to stand for questions at the appropriate time.
Okay, Katie, thank you so much. I think we'll go ahead and hear from all the proponents and then ask questions of any of them at the end. Okay, thank you. Now we'll call on Shane Rraw, the Executive Vice President of the Kansas Bail Agents Association. Welcome to committee.
Thank you, Madam Chair. Well, you've stolen my introduction from me, but I am the Executive Vice President and Legislative Chair of the Kansas Bail Agents Association, and I've been a bail bondsman in Johnson County for the past 38 years. For those of you unfamiliar with bond, Katie covered some of that, but posting a bond with the bail bondsman typically means paying the bondsman a percentage of the bond, usually 10% of the face amount of the bond, and the bondsman agrees to pay the full amount of the bond to the court if the accused defendant does not show up for trial. Once the bond is posted, the accused is released from custody pending that trial. That's sort of the 30,000-foot version of how that works. If anybody wants to know more about that, I've got like 30 hours of my podcast talking about the intricacies of bail, but I'm sure you don't want to hear that. However, there is a practice going on recently in the industry that I'll just refer to as discount bonding, and Katie used that term as well. This is the practice of bondsmen posting bail for either little or nothing down, often for those accused of violent crimes. And we feel that this practice is having a negative impact on both the industry as a whole and on public safety in those areas where it's going on. Now, I've referenced in my written testimony the case of Norma Williams, the grandmother in Sedgwick County who was shot and killed in a road rage incident, whose killer was released on a $500,000 discount bond, which caused a public outcry. People didn't understand how an accused murderer was getting out on a bond so small, or not so small. It was a large bond, but with very little security put up on that. However, there's another case that I want to touch on because I think that some of the other conferees are going to talk about the Williams case. But this other case, I think, is a better representative of how discount bonding actually impacts public safety. And this is the case of Larry Armour. Mr. Armour was arrested for 2 different armed robberies, including a carjacking at knife point in a grocery store parking lot just before Christmas. After a police chase, he was captured and booked into jail. He was charged with both armed robberies, and his bonds were set at $100,000 apiece. At the time of his arrest, Mr. Armour gave a hotel in Wichita as his home address and listed his most recent job as 6 months earlier in Oklahoma. So he was unemployed, transient, and charged with violent felonies. Yet, on January 12th, both $100,000 bonds were posted, and he was released. Clearly, these were discount bonds. He clearly does not have the assets to post $200,000 worth of bonds, and I doubt it doesn't appear that there was anybody else in his family or friends or support network that could help him with that. However, about 2 weeks later, Mr. Armour stole his roommate's car, again at knife point, and again led the police on a car chase. But this time he abandoned the car, broke into a nearby house, and took the resident hostage. Police surrounded the house, began a negotiation with him, and ultimately, as Mr. Armour was threatening the hostage with his knife, Wichita police shot and killed him. So now we have a dead man, a traumatized citizen, and a police officer who had to kill a man, all because discounted bonds caused him to be released when he probably shouldn't have been. This is a problem. It's a problem for public safety. It's a problem for the industry as a whole. The bill that we're pushing here proposes to address this problem by placing limits on the ability to post discounted bail. It established that the fee for bail would be at least 10% of the face amount of the bond and requires a bonding company to collect at least half of that upfront prior to posting bond. In the case of Mr. Armour, that would have been requiring a $20,000 bond fee, of which $10,000 of which would have been paid up front in order to secure Mr. Armour's release from custody. This practice has been done elsewhere and is becoming more widespread. If you look at my testimony, I've provided several examples of other states and jurisdictions that have implemented this sort of program to combat just this problem. Now, historically, professional surety bail has been the most effective method to secure both appearance and public safety. And we don't want that to change. We don't think the general public wants that to change. But of course, this is dependent upon a properly written surety bond with the fee collected and a member of the defendant's community support network, which is shorthand we use for friends, family, coworkers, people that have some sort of vested interest in the defendant, guaranteeing the bond. Someone close to that defendant who has a vested interest and a legitimate interest in making sure he appears in court and stays out of trouble. It is our position that placing a reasonable minimum on what a surety must charge and collect before posting bail will lower the instances of additional crimes being committed by defendants on bond and will soothe public fears about violent criminals being released with little security. Additionally, maintaining an option for partial financing by the surety will still ensure indigent defendants and their families have some recourse to bail. Now, in addition to the 10%, as Katie mentioned, we're working on trying to increase the professionalism in industry. KBA has long introduced legislation and championed the idea that convicted felons cannot work in the bail bond business in any capacity. Bail bondsmen proved that the district court cannot be felons. However, there is no such restriction in the municipal court statute. This bill attempts to bring some parity between the district court and the municipal court bond practices by requiring that compensated sureties are bound by the same professional standards in municipal court as they currently are in district court. Specifically, they must be a Kansas resident, current on their continuing education requirements, and not be a convicted felon. I just want to point out, because this was raised by some of the municipal court, it was not our intent to restrict the ability of the municipal court judge to approve specific compensated sureties. We just wanted to clarify that if you did approve a compensated surety in municipal court, that compensated surety had to comply with the standards for acting as a compensated surety. The bill also establishes, again, a non-exclusive list of prohibited behavior that could result in the court suspending or terminating the authority to act as a bail bondsman. These offenses include filing false statements, bribing officers at the jail, paying gifts or bribes, failing to pay bond forfeitures, and employing felons in any capacity. So, you can't get around, I'll just have you come in my office and bring in your felonious friends to help bring bonds in. You wouldn't be able to employ a felon in any capacity at all. Now, the other issue is we're concerned about the differing amounts of bonds being set in municipal courts. This is not being done all over the place, but there are several municipal courts that are engaged in the practice of setting differing amounts of cash bond and surety bond. What they'll typically do, and I'll just give an example because I believe it's in some of the opposition testimony, is they might set a bond at $1,000 surety, but then give the defendant the option to post $250 in cash. We think there's a constitutional concern on this. The Kansas Constitution does guarantee a right to be bailable by sufficient sureties. So we think that if you're going to set a bond at $250 cash, you should be allowed to post, as a defendant, you should be allowed to post that $250 bond with a surety as well. So basically, the bill would simply bring, that is already a requirement at the district court level. The district court is not allowed to set differing amounts of bond, whether they're cash or surety. And we think that's in compliance with the Kansas Constitution as well. So the bill would essentially just bring the municipal courts into municipal court practice into line with what the district court practices as well. The bill has multiple other components in it. I have 7 or 8 pages of testimony with footnotes and stuff. If anybody has any questions about that, I'll be happy to answer those. I think I kept it under 5 minutes. So.
Thank you. We appreciate that. I'm sure we might have questions. So if you'll just stay, we'll go ahead and hear from the other proponents and then ask questions.
Thank you very much. Thank you all.
Okay, committee. Now we have, let's see, Travis Rakestraw, Wichita Police Department. I believe it's WebEx. Is that correct? Yeah. Okay, Travis, welcome to committee.
Thank you very much.
We appreciate you being here. We can see you and hear you.
Okay, great. Thank you. As introduced, I'm Travis Rakestraw. I'm a captain with the Wichita Police Department. This concern of ours really started to come about over the last couple of years. We started noticing people that had been arrested and booked into jail on extremely violent crimes were able to bond out rather easily. And it was something I hadn't seen earlier in my career. And I think most of my coworkers were under the impression that when you bonded out of jail, you were required to put up 10%. As we kind of dug deeper into this problem, we noticed that people were bonding out for like 1-2% bonds, and this really caused us great concern because the problems, the crimes that these people were committing were very dangerous. We had strong public safety concerns, and this was especially true when it came to domestic violence and to gang-related issues. With domestic violence, many times these people had spent a great deal of time stalking their victims, threatening them, committing violent acts, and then now this victim has concerns because this person who has intimate knowledge of their life, their friends, their family, where they may be staying at, is now back out on the street. And so we had concerns for the victim and what could potentially happen in the future. And the same kind of went on with the gang violence that we see here in Wichita. When someone was arrested, a gang member, then oftentimes when they were put back out on the street, they're in a position where that gang feud is still going on. It fuels more violence. And so we have a continuing action that really could have been prevented if this person was still in jail. So we were very happy when we heard that this bill was being introduced, and we are very supportive of any action we can take that to make sure that people are staying in jail when that's the expectation of the community. That's the expectation we had when we first started going down this road. So we are supportive of this bill, but we did offer a recommendation. I put that in my written testimony. As I understand it, this bill allows for 5% down and 5% financing. And we made a recommendation for 10% with no option for financing on any violent felony. At one point, we kind of were looking at, okay, maybe if we made a recommendation to say if it was a level 6 and above violent felony or a person's crime, but really that doesn't incorporate some of the most severe domestic violence cases, such as your aggravated domestic battery, which I believe is a level 7, stalking, which is like a level 7 or 9, criminal threats, which are level 9s. And we wanted to encompass all those persons' felonies to ensure that people are staying in on that 10%. So we are supportive of this bill. I don't pretend to know all the ins and outs of the bill, but in regards to the bond issue, that is really what we're supportive of, and we want to keep that. It's our hope that maybe you will pass that bill.
Okay, thank you so much. As I've mentioned to the other proponents, we're going to wait. We have one more in-person proponent, and then if you can stay on, we may have a question. Okay, thank you so much. Committee, now we'll have Sheriff Jeff Easter from the Sedgwick County and the Kansas Sheriff's Association. Welcome back to committee, Sheriff Easter.
Sorry, I had to unmute. Good afternoon, and I appreciate the opportunity to speak, Chairwoman Humphreys and committee. I'm Jeff Easter. I represent the Kansas Sheriff's Association. We recognize that bonding companies are an integral part of the criminal justice system. We also recognize that in the Constitution of the United States of America, the 8th Amendment protects individuals from excessive bonds, and we absolutely agree with that. Over the last several years, we've had bondsmen, particularly property bondsmen, that there has been some issues here in the Wichita area. If you don't know it, insured bondsmen, there's checks and balances in state statute, plus with their insurance companies on what they can do and can't do. It doesn't necessarily have the same checks and balances with property bondsmen. And that's what this bill, I believe, is trying to fix. I will tell you that we've had two particular cases. Most of what I'm going to talk about here with the 1% bonding has taken place over the last year. We've had two particular cases that were homicide cases that individuals posted 1% and could finance that 1%. So they were putting basically nothing down. Both of them had $500,000 bonds, which meant that they were posting $5,000 that they could finance. So they were getting out on a homicide charge without putting any money down. That caused quite a few concerns, a lot of newspaper articles, a lot of phone calls to the sheriff's office asking why we're letting them out, and us having to explain to them we're just the middle people. Bondsmen enter into a civil contract with individuals that they're bonding out, and we simply assist in obtaining the money for the courts to secure them coming back to court. And so another piece that I want to talk about, the e-bonding piece, we were the first in the state of Kansas to look at e-bonding because we were having problems with bonding companies coming in up to Pro Visit on a bond. So they'd meet with the prisoner up in Pro Visit inside the jail, and then they'd look down the list and see who else just got booked, because they can look at that on our website. And then they would ask us to start calling them up because they were their bondsmen. What we found out was they were never called by these individuals that were booked, and they were securing their bonds by simply sitting in our building for hours at a time doing this. We felt e-bonding would resolve that. With that said, we were getting ready to put that into place, and we did more extensive research after it was made known to us that there's no checks and balances on the backside of this, which means a bonding company could pay somebody minimum wage to sit there all night, click on every bond that comes in at night, say that they're the bondsman, and then utilize the bondsman's license number to post those bonds without being the licensed bonds person all night long. And there was no way for e-bonding or us to know that that was actually the bondsman at 2:00 in the morning that was bonding that person out. We decided not to go that route now because that opens it up way too much for somebody to take advantage of the system. And there was really no checks and balances for us to be able to catch that. So we are in agreement with the e-bonding portion of this bill. One of the things that I do want to clear up at the bottom of my testimony, I had met with an assistant district attorney who told me how judges can forfeit bonds, and what you see at the bottom of my testimony is not actually by state statute. State statute, you have to have 60 days after notice to file that appearance bond. What you see in my testimony is the rule the district court in the 18th District Court here in Sedgwick County has put into place, which is different than the state statute. So please disregard my bottom statement. Finally, I'd like to say in reference to municipal court bonds, and we hear a lot about how people can't afford to get out on bond because of their money situation, those type of things. We have a bonding schedule here for there's 18 different municipal courts here in Sedgwick County. They're all on the same bonding schedule now. And that bonding schedule is set by those judges. In most cases, with exceptions of domestic violence or sex-related misdemeanors, most misdemeanors are ORable, or own recognizance, which means there is no bond set. At one point during COVID, we had 128 homicide suspects in our custody. We still, with our population, the majority are violent crimes. Most property crimes, almost all drug crimes are OR'd. There's several reasons for that, but it's the violent crimes that we think really needs to be targeted on this, because it does create community safety concerns, public safety concerns, when folks are released for $5,000 that they don't even have to pay up front. And that's why we're supportive of this bill. And at a later point, I'll stand for questions. Thank you.
Okay, Sheriff, thank you so much. We appreciate it. committee, we will go ahead and ask questions now. I'm going to start because there's one, Shane, maybe this is just I think it's just a question that maybe others have. I don't know. My question is, with the discount bonds, does the bondsman actually pay the court like that 10% or some amount of money, and they just don't charge the defendant? Or is there no money transaction at all?
In all bond instances involving a surety bond, there's no cash exchange to the district court until the bond has been forfeited and a judgment has been rendered. So the bonding company signs the bond contract, which is a promise to pay that entire bond in the event the bond is forfeited and then judgment is taken. So there is no actual exchange of funds.
So then they can just decide on their dealings with the defendant is
Yes.
the way it's been. Okay.
Currently.
Thank you for that clarification. I appreciate that. Okay, committee, who has questions? Representative Miller.
Thank you, Madam Chair. It's been a few years since I did this, but I did do this for a while. Sheriff Easter, I got confused by your testimony. You started talking about municipal bonds, and then you sort of morphed into violent crimes. The most a municipal court can handle is a misdemeanor. You want to clarify that for me? You were talking about municipal courts, and then you brought up 125 homicides. I didn't see the relationship.
Okay, what I was trying, and I'm sorry for the confusion, what I was trying to explain is because there's talk about municipal court bonds on this. Municipal court bonds are controlled by municipal court judges. What we have here in Sedgwick County is a bonding schedule. And most misdemeanors, with the exception of domestic violence and misdemeanor sexual crimes, are ORable bonds. So that's one point that I wanted to make. The second point is the majority of what we hold here now in jail is violent criminals. The misdemeanor crimes, we don't have too many people on misdemeanor crimes inside jail.
Right. Let's go back to your first point. When you mentioned that most of those bonds were OR, my question is, so what's the issue? An OR means that
No.
you promise to appear in court.
Yeah, there's no issue with it, but there's discussions in this bill about how this bill could affect municipal court bonds.
And I guess that's what I don't understand. I don't understand what the problem. We talk about the seriousness of the charge and the risk of letting that person go, but I don't know how that relates to municipal court when all we're talking about is misdemeanors. And even in that, as I remember it, when I had someone who hadn't showed up a couple times, I could require a cash bond as opposed to even allowing a surety if they were a flight risk at all. And again, most of them were ORs. Almost always, people would appear, and I almost never had to say it's a cash bond only. So I don't even know why we're talking today about municipal courts. That's what I'm lost about.
The only reason I brought it up is because of what the bill is talking about and
Right.
explaining that. I agree with you completely, sir.
You would agree that we really don't have an issue here we need to address as it relates to municipal courts.
I'd absolutely agree with that. Yes, sir.
Now,
Representative Miller, so we kind of do two questions at the beginning, but I'm happy to come back to you.
I respect it. That's fine.
Okay, thank you. Other questions? Representative Carmichael, but I do have, I'm sorry, Katie, did you want to say something related to what Representative Miller was asking? I saw you raise your hand, and I'm sorry, then I ask about questions.
I guess our only concern about this, the municipal court judge still has the authority to set an OR bond. Our only issue on that was whether if the judge was setting a cash or surety bond, that those bonds should be in the same amount. Clearly, the municipal court judge still has the authority in the bond schedule to let someone out on a signature bond.
Go ahead.
The last point you made that they should be the same. Why?
Well, first off, we have the belief that it's a constitutional violation to set them differently. that the Kansas Constitution calls for everyone to be bailable by sufficient sureties, and so setting the bonds in differing amounts. So if I set a bond at $100 cash or $10,000 surety, I've effectively denied somebody the ability to use that surety bond.
And wouldn't that be an issue for the defendant to raise and not the bail bondsman?
Yes, but it's also a policy decision, I think, for the legislature to set that up. I mean, that is currently the policy at the district court level, that those bonds have to be the same amount. We were just trying to get that to where it was the same across the board.
Representative Carmichael.
Thank you, Madam Chair. Don't have a seat. I have a question for you, sir. My recollection is that, perhaps 6 or 7 years ago, in the days before COVID, that Representative Patton, Representative Ralph, Patton was chair, Ralph was vice chair, I was ranking member, that we were all invited by the chief judge of the Kansas Court of Appeals to attend meetings over at the Kansas Judicial Center as at least observers of a task force on bail bonds in Kansas, and that after much delay following COVID, etc., a fairly thick and lengthy report was rendered. Was your organization a participant in any of that?
Yes, there are quite a few references in that report that we authored and gave our commentary on and recommendations.
Yeah, and I apologize because I have not read the report now in 2 or 3 years, and my memory is getting worse with the passing years, as my wife will attest. But that task force made a number of recommendations concerning reforming bonds, particularly bail bonds, cash bonds, surety bonds, etc. in Kansas. You're, of course, aware of that?
I am.
Were any of those recommendations incorporated in this statute, or did this just all come from the police and the bail bond industry?
This is not a recommendation that came from the Pretrial Justice Task Force. I don't think the Pretrial Justice Task Force talked about the fees the bonding company charge and this issue of discount bonding. Their issues were more dealing with things like, should we look at risk assessment? Should we give more signature bonds? Those sorts of things. More lenient forms of release. And clearly this has no impact on the ability of the court to set a signature bond.
I'm sorry, Madam Chair. The witness must not have understood my question. My question was, does this bill incorporate any of the recommendations of that task force which labored so many years for reformation of bail bonds in Kansas?
No, it is not.
Thank you.
Committee, do we have any other questions? Representative Osman.
Thank you, Madam Chair. My question, I suppose, could go basically to you, but to any of the proponents. I'm trying to understand the problem that is trying to be solved with this bill. A lot of the stories that have been told are about, and you've told one as well, a violent criminal was released and did something violent, and that is a bad thing, clearly, but I don't know how that relates to the bail being set or the bond being issued on that. Because when somebody is released, it doesn't matter what size that bond is. If they are released and they do something bad, that's independent of what you're trying to solve here. So can you better phrase what the problem is that you are trying to solve with this bill, other than stopping criminals from being released? Because that is the point of bonds in the first place, is to allow people that freedom for trial.
I understand what you're saying, Representative. However, I do think that if the bond is done properly, in other words, if you're able to gather up members of their family, members of their community support network, the people who get out and are being watched by those family members that have invested money in getting them out of jail, they have a vested interest in making sure that person shows up for court. They don't want to go spend that money only to have that person get back in trouble in a week or two, and then they've just wasted that money and that person's back in custody. So our feeling on that is if this bond is done properly, it actually does reduce the amount of recidivism that occurs by people who are released on bond. I hope for that answer your question, but that's our position on that. If the bond is done properly, even though I understand people are getting out. They aren't necessarily going to engage in the same behavior if the conditions of their release are different.
Committee, do we have any other questions? Representative Lewis.
Thank you, Madam Chair. So I have a little follow-up on the discounted bond point. So I'm a bondsman. Somebody comes to me and says, I want you to bond me out. And, you know, they look at the risk assessment and decide to take whatever risk they take. And if their client doesn't show up, they're out the $500,000 in the case that you mentioned. In that case or those cases, I assume the discounted bondsman had to pay up. Is that accurate?
If the defendant fails to appear, if the defendant simply gets rearrested again, then then they can surrender that bond. If they haven't missed court, then it's a wash for the bonding company.
How about the case where the fellow then was killed by the police?
Well, he was dead before he had to appear in court. So no, they would have filed a motion for relief from the bond because he was no longer able to appear because he was no longer alive.
Really? So he didn't? Okay, that's interesting.
He had not failed to appear yet.
Right. Okay. I guess the broader question, if I might,
Go ahead,
is why shouldn't we let the market take care of that? In other words, why are we stepping in to tell the bondsman that they have to require 10% down rather than 1% if they're ultimately on that risk? And if they're not good about assessing risk, they're eventually going to be out of business.
And I agree with that. And that's an argument that I'm a very strong believer that market forces will take care of these problems over time. But it doesn't mean there aren't consequences along the way for allowing those market forces to come into play. If you said, okay, you can bond out anybody you want until you hit that wall and now you owe thousands of dollars or hundreds of thousands of dollars and there's all these people walking out on the street. I think there probably should be a little bit more guidance from the state on how that's supposed to be done. So, I mean, I very much agree with you on the market forces issue, but I just think that there's potential consequences for letting that play out till the end, where the market forces would come into play. And then one of the other issues that Sheriff Easter brought up is some of the policy considerations of how long it takes to actually get a judgment on bond. So there is that period of time. Statutorily, it's a 60-day grace period, but some districts will extend that longer than that. And so sometimes it takes longer for the market to actually adjust and fix that problem.
Thank you.
committee. Any other questions? Representative Mon.
Thank you, Madam Chair. Sir, can you explain the problem with the courts not really enforcing bond forfeiture, because that extends out the issue with regard to where that wall is.
Yes, Representative Mon, it does. There is an issue. I mean, the statute currently allows gives the surety at least 60 days, but that 60 days is conditioned on the filing of the motion for judgment on bond. So the process of how that works is someone misses court, the court declares a forfeiture of the bond, and then the state files what's called a motion for judgment on bond to enforce that forfeiture. That hearing has to be set out at least 60 days. The purpose of that gap is to give the surety an opportunity to get that person back into custody or give some sort of reasonable excuse why they're not there. For instance, they're dead, they're incarcerated someplace else. Those standard defenses. Now, if you have a district or jurisdiction that's fairly aggressive about pursuing those, then yeah, you're going to get a lot faster compliance. If you have another jurisdiction that is not as aggressive or is overworked in other issues or doesn't have the manpower to get to those as quickly, or they've made a policy decision that we're going to give additional time on this, then yes, it can take longer to hit that wall for the market to actually adjust on that if there's a long delay in pursuing those motions.
And do we have a problem with judges not actually then enforcing those judgments against bonding companies?
not in my experience. I think I just had a judgment entered against me today on somebody that's missing. So no, once that motion gets in front of the judge, it's pretty black and white as to whether or not either your person's back or they're not, or you have an excuse or you don't. And if you don't and they're not back, yeah, you have to pay that.
Hang on just one second. Representative Miller, do you have any more questions? And then I'll come back to Representative Mon.
No, his questions are better.
Okay, Representative Mon, go ahead.
This one is for Sheriff Easter, if you're still online with us, Sheriff.
Yes, sir, I am.
Okay. So my question goes to, I know your department is always concerned about the number of the overcrowding in the jail. How will this impact the jail problem?
I don't think it's going to impact it that much. Like I said, we first started experiencing this last year. Prior to that, I'm not aware of these kind of practices taking place. And so, we're talking and it's only been on the violent crimes that I've seen it. And you've heard some of the stories. There's been a few others that have occurred, but I do not believe it will be a major impact on the jailing systems around the state.
Thank you. Yeah, that's all. Thank you.
Representative Carmichael.
Thank you, Madam Chair. Sheriff Easter, if you're still there at hand, can you hear me clearly?
Yes, sir, I can.
All right. You and I agree on a lot of things, but today may not be one of those days. You probably heard the testimony from the man from the bail bonding industry saying that this bill does not contain any of the recommendations that were the product of the Supreme Court's Special Task Force on Bail Bonds, headed by the Chief Judge of the Court of Appeals. Those recommendations were designed to assure the public safety and modernize bail bonding in Kansas. Why didn't you, well, don't let me put it argumentatively, did you and the folks there in Wichita who were so concerned about these two incidents we've heard, did you give any consideration to perhaps, instead of supporting a bill which comes from the bail bonding industry, instead propose some legislation that would adopt those well-founded, well-thought-out recommendations of the Supreme Court's task force?
To answer your question, I believe that was 2 years ago, and I actually gave testimony to that particular committee. And in that, the KSA supported some of the ideas that were proposed. You had legislators in there, you had judges, you had defense attorneys, you had district attorneys. My question back is, they were part of the committee, why haven't they? All I did was provide testimony in support of some of those changes. I didn't think that it's KSA's prerogative to introduce legislation based on several members being in the committee, including legislators.
Sheriff, KSA certainly does introduce through their representatives legislation in this legislature designed to help protect the public safety. True?
That's correct.
But this was not a topic on which the KSA thought that they would try to advance these evidence-based recommendations to improve the safety of bail bonding. Instead, they waited for the industry to propose this bill.
I would agree with that, sir. Yes. I would also say that we've given testimony in several committees, and different entities that were a key component of those entities were the ones that have introduced those bills that we've either supported or not supported.
Well, I appreciate the candor of your answers, Sheriff. Hopefully we can be together on some bills later this afternoon.
Absolutely. Thank you.
Okay, committee, any other questions for the proponent? Representative Miller.
Thank you, Madam Chair. For anyone that wants to answer, on page 5, we begin a list of reasons that a court can suspend or terminate the authorization to write bonds. It continues on to page 6, and one of the reasons listed reminds me of something Jesse James once said when they asked him why he robbed banks. He said that's because that's where the money was. We have on this list a prohibition of soliciting appearance bond services at any jail. Why? Isn't that where the prisoners are?
What line is that on?
That's on page 6, line 2.
Thank you.
This is probably mine.
If you could introduce yourself.
Sorry, Shane Rraw, Kansas Bay Legends Association. Most of these prohibitions were drawn from other state statutes. This is not something we just made up on our own. And as I think Sheriff Easter testified in his testimony, they were having an issue of bondsmen going up, just picking out names and bonding people out. We're spending hours and hours in the lobby of the jail trying to essentially hustle up business, to grab people they are. Yes, that is where the people in custody are, but it doesn't mean that you should be sitting at that jail handing out cards to everybody that comes in the door of the jail. And so we don't think that's a good look for the industry. And we don't think that's a way to set up bonds properly.
And your reason is because somebody else has this prohibition, so we should.
Well, that's one way we look at passing laws, is look and see what other legislatures have done. And this has been done in multiple other states, some of these prohibitions.
And I know we come at it from different perspectives, but if somebody does this, I don't see what the public interest is in prohibiting it. It might be in your interest because you don't want to hustle, but looks to me like you're infringing on somebody that wants to out hustle you, and I don't see what the public interest is in this prohibition.
Again, if someone has to go to a jail, probably being accosted by bail bondsmen as they walk into the jail to visit their friends and family, I think is a behavior that the sheriff's office would like to limit. I mean, I'm perfectly fine with sending up people with T-shirts and cards and sitting out in front of the jail. I don't really want to do that, but we certainly can if that's the way the state would like us to do it.
So this is something that the sheriffs are asking for, not the bail agents.
No, the sheriffs not specifically asked for this, but I was just referencing.
You said that they were the ones that were bothered by it.
Based on Sheriff Easter's testimony, he was making that point that was a problem in the Sedgwick County Jail.
I didn't hear that, but maybe I just wasn't listening close enough. Thank you.
Sure.
Okay, committee, anything else? Anyone else? Questions? Okay, if you would also look, we have written proponent testimony from Laura Frisbee, Owens Bonding, Dennis Burnt, B&K Bonding, Rick Morey and Michael Crow, Morey and Crow Bonding Company, LLC. We have a written opponent, Keith E. Drill, a municipal judge in Mission, Kansas. Committee, since we don't have any in-person opponent testimony, I really would encourage you to look at the written opponent and also the other written proponent testimony. Before I close the hearing, is there any other questions? Is there anyone neutral? Is there anyone in the audience that would like to come forward, proponent, neutral, or opponent? Okay, thank you so much. I'll close the hearing on House Bill 2755. Committee, now we are going to work some bills. So we have a few minutes. I do know, or I think we've got some amendments and things coming up. So we're going to start with House Bill 2660. It was the bill that we heard on Monday from the Secretary of State's office. Pull that up or out, whatever you're doing. So I believe there's amendments. Oh, yes, please. Our revisor will do a brief overview of the bill to remind you.
Thank you, Madam Chair. House Bill 2660 modifies requirements related to certain business entity filings with the Secretary of State. It authorizes a change of registered office address by a current occupant under the Business Entity Standard Treatment Act, and it changes the information required in an amendment to the Articles of Incorporation of a corporation, or a cooperative, excuse me. And I can take any questions.
Do you have any questions for Natalie about the bill? Okay, Natalie, we do have amendments. An amendment?
If you're telling me that there is an amendment and asking me to do something with it, then yes. Yeah.
And so we have our amendments, they're going to be physical now. And Kathy's not here. I think she probably plans to, if she were here, she would also put it online. She had to go home sick today, so I'm sorry if that inconveniences anybody. Because I'm the one bringing this amendment, I'll just go ahead and explain it. Or Natalie, do I have you explain it first? Okay, I'll just go ahead and explain it. The reason I'm bringing it is because it's technical. It's not, I don't believe it's controversial, but y'all take a look and see what you think. There are several changes that the Secretary of State's office asked, and three of them came from the Kansas Bar Association. After looking at it, they wanted a few changes. And then one came from the electorate cooperative people, asked for a few changes. So, Natalie, I don't know if it makes sense to go through each one of them. It seems like a lot, but it's actually pretty technical. Who has questions on this? Take a minute to look at it. Yeah, take a minute to look at it. I will say in section 1D, so that would be the change that's on page 2, line 9. If the recovered entity receives, and it says instead, it used to say upon receiving, it's just if the covered entity receives. And the reason is to ensure the duty to change the registered agent stays on the entity. And this new section is a narrow exception. So it's giving notice for the entity to change the registered agent. In sections, there's identical language for different entity types, and they're deleting the phrase at the close of business. That's in sections 2, 3, 5, 6, 9, 10, 12, 18, 19, 21. And the reason is they thought it sounded as if they could only file after the close of business or like incur over time. And so they changed it. They deleted the phrase at the close of business. You'll see that. Section 15 is on page 20. Undeleting an original copy executed by a governor of. Governor is defined elsewhere in our law, meaning as any government official with authority. Seems more direct, more accurate. That's the reason for that change from the Bar Association. And then section 16, undeleting the struck phrase, so the entire section is removed from the bill. And that's on page 21. And the reason is limited partnerships in theory do have a dissolution date, which may be some public benefit to know that. And those are the changes, I believe. Representative Smith.
So I'm looking on page 24, and not because I understand all the previous.
Not because you understand. What did you say?
But I get to page 24, and I notice there's no page 23, but we've edited part of a paragraph that begins on page 23. So I went to the actual bill to look at what that says. Holy wow. So it changes the prescribed information concerning the limited partnership, go through the strikes on the day the report is filed with the Secretary of State. Prior to that, what's stricken is could be a completely different date. So do you know the purpose behind having that part changed? Why have we changed it to a particular day rather than it looks like somebody had a particular reason for saying at the close of business, the last day of the tax period, next preceding the day, blah, blah, blah.
Yeah. So that was in the bill originally. So the bill, if you recall the testimony from Clay Barker, they're putting a uniform date when all the reports are due rather than different ones according to the different kinds of entities. So that one that said December 31st, they're putting all the dates on the same day, which I think is April 15th, but I'm not sure.
Don't get me wrong. I think it makes a lot more sense to say it this way rather than something from Monty Python. But
so that's not part of the amendment. That's not part of the amendment. That was part of the bill. So the amendment is just striking lines 1 and 2 on page 24 at the close of business. Again, and the reason for doing that was it sounded like to
Monty Python.
the Kansas Bar, or sorry, it sounded to the electric cooperative people that if you say that, it seems like it's overtime.
Thank you.
That's what they said. So, but when we get to the bill discussion instead of the amendment discussion, you could bring that question up. Okay. Okay. Representative Miller.
Thank you, Madam Chair. On page 21, the amendment that reads strike all in lines 11 through 29, looking at the bill, all in lines 16 through 29 are being stricken. You use the term undelete. And again, if this is Natalie's language, I've learned a long time ago to never argue with Ms. Scott, but should that not, instead of saying strike all in lines 1129, wouldn't it be better if we said reinsert? Or am I reading this wrong?
Thank you, Madam Chair. So actually what's happening in that one is we're removing the entire section from the bill because the change being made is no longer desired. And so if we reinserted, or if we changed that language, reinserted the stricken language, there would be no change to the law. So we're just going to take the entire section out.
It looks like that's what we're already doing.
No, I think it's kind of because the balloon's not printed in color, but the original bill is striking paragraph 4, the latest date upon which the limited partnership is to dissolve. You can kind of see it's like double strike right there. Okay. But the amendment is just taking out that entire section.
I see now. Thank you.
Thank you. Thank you for asking that question. It's a good explanation. Okay. Representative Bourgeon.
Thank you, Madam Chair. I'm a little bit unclear. Can you restate where these amendments came from? And then do we know has the Secretary of State's office reviewed these proposed amendments and are they okay with them?
Yes. So actually, the reason that I'm bringing this up, the Secretary of State asked me, they talked to Natalie, they got the amendments done, but they asked it to be brought. And they're a little bit, they seem extensive. I might have had Clay do it. He is a sick child, and so he's not able to be here today to explain everything if we needed him to. And usually we don't have someone explain amendments, even though this is a little bit extensive. So I'm bringing the amendment, and it came from them. But in his explanation to me of what it was, he explained some of them came from the Bar Association and some of them come from the Electric Co-op, but they agreed on all of them and wrote the amendments.
Okay, I appreciate that explanation. Yeah. Thank you, Madam Chair.
Representative Carmichael.
Thank you, Madam Chair. I think my first question is best posed to our reviser, and I apologize. I don't have a color copy of this. I am not able to distinguish from the copy in front of me what is language that was stricken in the original bill as opposed to what is language that is being stricken in the amendment. And I'm sure that there's some code about double strike or thicker line strike but I can't discern a difference. And I don't know if we need to go through this because it's more than just Monty Python here. This is substantive, important legislation, and I need to know what the amendment does. And I don't know if that means we have to go through it line by line, but I don't know what's in the amendment because I can't tell the original from the balloon.
Okay, well, just one. Hey, I appreciate, that's a great question. And what we're talking about is next time we hopefully will be able to email you. And so you'll be able to see, but Natalie can go through it for us.
Thank you, Madam Chair. I look forward to that.
Yeah. So the reviser, she is going to share the colored version on WebEx.
And I can use that to go through line by line.
Does that mean we need to log into WebEx, or is it just those of us whose vision is good enough to read across the room?
I'm going to share it on the screen, and then I'm going to go through line by line.
Okay, thank you.
Okay. So in the title and the boxes to the side, can be helpful if there's only some strike in each line, obviously. So in the title, in line 8, we're striking and limited partnerships. In line 11, we're striking the KSA number 56-1A-151 because that's the section that we are removing from the bill. On page 2, in line 18, like the chair mentioned, we're striking the words "at the close of business" because of the timing issue that she discussed with the cooperatives.
I'm sorry if I might interrupt. There's a change up here at line 9, though, too, isn't there?
Yes, I thought. I mean, if it has a direct line to it, I didn't understand.
Okay, I understand what we're doing. I appreciate that. Okay, thank you.
On page 3, the strike in line 32 is the words "at the close of business."
All that's being stricken is at line 32, the 5 words.
Yes.
And the rest of that is in the original bill.
Yes.
And we are inserting a comma, obviously. Okay.
Same on page 5 in line 9, the words "at the close of business" being stricken.
I'm with you.
Same with page 6 in line 1, "at the close of business." It's being stricken.
I bet it's going to be at the close of business again.
Yep.
I'm starting to track.
At the close of business is stricken. It goes on lines 7 and 8. On page 11, same line 26, "at the close of business." It's being stricken. Page 13, "at the close of business" on line 6. Page 16 in line 32, "at the close of business." Page 17, line 27 and 28, "at the close of business." The change on page 20 is pretty clear there with the arrow where that new language is going to go. Page 21, we discussed this. We're removing the entire section, so all of lines 11 through 29 are being stricken. Page 22, line 25, "at the close of business" is being stricken. Page 24, lines 1 and 2, "at the close of business" is being stricken. Same with page 26, line 14, "at the close of business." Page 27, line 28, we're striking "at the close of business." And then finally on page 28, in line 38, we're striking that statute number that we're removing from the section.
That, Madam Chair, Madam Revisor, that's actually very helpful to me, because when I first looked at this, I thought this was a rewrite of a whole bunch of things, and it's apparently not. My second inquiry, understanding, of course, that we have yet to receive a motion even on the bill, and I could, or excuse me, on the amendment, and I could defer until we have a motion on the amendment, or I could ask my substantive question now. Could someone enlighten us? I mean, I assume a lot of this came from Secretary of State, but I just want to know kind of who's responsible for what. Can someone tell us what came from the cooperatives and what came from the Bar Association, as opposed to what came from the Secretary of State? Because if I make a mistake here today, I want to know who to blame.
I'd be happy to tell that.
Thank you.
All of the at the close of business was all from the electric cooperatives. That was their piece of it. The other ones where section 1D that said upon receiving, or now it says if the covered entity receives, that's section 1D, that's from the Kansas Bar Association. Section 15 that had to do with the word governor at the end, that I think that was on page 20, that's from the Kansas Bar Association. And then the whole section about limited partnerships that's taken away, that is also from the Kansas Bar Association. And that had to do with limited partnerships, in theory, do have a dissolution date, which might be of some interest for the public to know. So they took that section out.
Well, given that I'm thinking about dissolving my own LLC, maybe I ought to wait till this bill passes.
Okay, so I'm going to go ahead and move that we accept amendment to House Bill 2660. And do we have a second? Representative Owens. Okay, any other discussion about the amendment? Okay, thank you. I'll close. And all in favor of the amendment, say aye.
Aye.
Opposed, no. Okay, the amendment passes. So now, are there any other amendments to this bill? Okay, do we have a motion about House Bill 2660?
Madam Chair, I move that the committee pass House Bill 2660 out of committee as amended.
Do we have a second? Representative Smith seconds. Okay, discussion on the bill now. Any discussion? Okay, no discussion. Representative Mon, you may close.
Close.
Okay, committee, we have a motion to pass House Bill 2660 favorably for passage. All those in favor say aye. Opposed? Okay, thank you. House Bill 2660 has been passed.
I'd like for my affirmative vote to be recorded in the minutes, and also that we express that the bill was recommended as amended.
Thank you. Anyone else want their vote recorded? Okay, thank you very much. Okay, committee, we are now going to look at House Bill 2675. That was the bill that was about third-party visitation that came from the Judicial Council. Do we have any amendments on that bill? Okay, no amendments that I see. So do we have a motion on that bill? Representative Mon.
Madam Chair, I recommend that the committee pass House Bill 2675 out of committee favorably.
Thank you. Do we have a second? Representative Osman seconds. Okay, discussion on this bill, committee. Okay, Representative, you may close on your motion.
Thank you, Madam Chair. I close and encourage the a vote on 2675 favorably.
Thank you. Committee, all those in favor of passing House Bill 2675 favorably for passage, say aye. Opposed? No? Okay, thank you. That bill is now passed also out of
Madam
committee.
Chair, I request that my affirmative vote be recorded in the minutes of the meeting.
Thank you so much, Representative. Is there anyone else that would like their vote recorded? Okay. Okay, committee, we are now going to look at House Bill 2606, which is the civil asset forfeiture bill. Do we have any amendments on the civil asset forfeiture bill? It's House Bill 2606. Any amendments?
Madam Chair, thank you. I do have an amendment that was basically requested by the law enforcement community to change the word shall to may, allowing the judge more discretion on how they proceed.
Okay, thank you. Do we have a second on the motion? Representative Smith, seconds. Okay, and I think you've explained your amendment. Representative, does anyone have any questions? Is this in the right one? Oh, I don't know. I got a good one. Yes, and it's page 18, and it changes may to shall. I'm happy to pass this around, pass it down so people can get a look at it. Committee, are you okay taking a look at it like this since it's a simple word change?
Madam Chair, I need to see the proposed amendment in context in a balloon or in some fashion.
Okay. Representative Schreiber, is it line 3? Or who has that piece of paper? You, oh, she took it. Okay. She'll be right back. Okay. I don't have that one. That's what I was thinking. I think we need to wait even to do another amendment. So if we can just wait a second. So is anyone doing anything fun for Valentine's Day today? You have on your red shirt. We know you knew it was Valentine's Day. Oh, boo. No. Is he called? Just doing. Committee, I'll tell you that the agenda is not exactly correct about what bills we're working. We're not working 2676, which is one of the suicide bills. And we're also not working 2592. The four that we're working today was the Secretary of State, third party visitation, which we've done. We're now working on civil asset forfeiture, and we're going to work on the CORA bill. Those are the ones we're going to do today. This was your. Okay, committee. So now you do have the correct amendment. And Representative Mon, did you move your amendment? You want to go ahead and do that?
I'm not sure if I did, so for the sake of good order, let's go ahead and do that. I move that the amendment on page 18, changing the word shall to may, be accepted by the committee.
I'll second that.
And I think Representative Smith already seconded. Thank you. Okay, so now we have discussion. You have it in front of you. Representative Titus.
Thank you, Madam Chair. I have some concern about this change in isolation because the point was brought up during the hearing that because this may now is entirely up to the judge, that it may actually not help fix some of the problems in going through this process, because an attorney may be afraid to take this case because there's no certainty of recovery. So that's my first concern, and mostly because this is in isolation. There was some talk about tying it to if there was some sort of fault of the officer or some act not in good faith. I think that would maybe change how this looks, but I'm inclined to oppose this as just a standalone may.
Representative Owens.
Thank you, Madam Chairwoman. And I do understand that this was a bit of a concern to law enforcement, but I didn't get the feeling that this was a significant concern for them. And to be totally honest, being that this is such a highly collaborated on piece of legislation, I'm going to take the position that we don't need to amend this bill. And I plan on carrying that position throughout the floor debate as well. And as far as I'm involved in it. And so I'm going to oppose the motion just to ensure that this legislation stays the way that it needs to stay. Thank you.
Representative Neely.
Thank you, Madam Chairman. In speaking with some of the people afterwards yesterday, I felt also, because I considered what you were saying there, and most of them said that they preferred that it stayed the way it was, and so therefore I also am going to be voting against the amendment.
Representative Osman, then Smith.
Thank you, Madam Chair. I would echo all the previous statements, especially Representative Titus says, when we change shall to may, it, I think, fully defeats the purpose of what we hashed out in the Judicial Council, which is fee shifting. And when somebody isn't guaranteed that they will be compensated, they're not going to take the case. And that was the whole point behind the rationale for why we put this in here in the first place.
Representative Smith.
This is an awkward situation in this amendment because it actually works in tandem with an amendment that I'm going to propose that addresses what Representative Titus was speaking to, in that we Representative Lewis yesterday expressed a phrase that was questioned whether or not it existed. And it sounded very much to me like a rebuttable presumption. And so what I asked for my amendment to do was to create that rebuttable presumption that the agency would not pay unless the court finds that they acted in bad faith. And I can talk about that afterwards. But it actually works in tandem with the moving the shall to may, in that all occurs, my amendment will occur prior to that last statement that the court shall or may order the seizing agency to pay based upon the amendment that I'm going to. And I know that really muddles the water a little bit.
So would you be willing to say, do you in your amendment change shall to may also, but you add other language? Or if you don't want to say, you don't need to. Okay.
I think I'm not sure how you would do that.
Well,
Okay. Go ahead, Representative Miller.
all he needs to do is offer this change in tandem with your other change. Is it?
I'd be willing to do that.
I'm not saying I'll vote for it, but that if you want this change conditioned upon your other change, just do it in tandem.
Okay, just a second. Okay, so committee, I feel like the right way to do this is either you offer substitute motion, or we dispense with this motion first and get it done, or the representative withdraws his motion and then we move to your motion. I think that's a proper way to do it. Representative Goddard, do you have a question? And then we'll come back to this issue.
Well, thank you, Madam Chair. And my comments refer to the amendment that's on the floor.
Okay, yeah.
Presently. I was looking through the report of the Special Committee on Civil Asset Forfeiture. If you go to the last page of that report, there's conclusions and recommendations. And one of the conclusions and recommendations is, and I quote, establishing that a seizing authority can be ordered to pay a prevailing claimant's attorney's fees. So I think this may is consistent with the terminology of can in the recommendations from the special committee. That's all. And thank you, Madam Chair.
Oh, thank you. Thank you for reading that. Okay, I'm going to ask the maker of the motion. Are there any other comments? Okay, the maker of the motion, would you like to continue on? It's up to you. Right now, your amendment is on the floor at the moment. And then Representative Smith, unless you want me to call on you to offer a substitute motion.
So I think the cleanest way to do this is to close on my motion. And then if it fails, there may be a friendly amendment offered to Representative Smith's amendment. I think that's the cleanest way of doing it.
Okay, so would you like to close on your amendment?
Yes, I'll close.
Okay.
So the reason I offer this amendment is because obviously all cases are different. And judges, what they do is make decisions based on facts and circumstances, and giving them the discretion, giving the judicial branch the discretion to actually hear the individual circumstances and case before making a decision makes more sense than just binding their hands and saying that they shall do this. And so the may language is more in line with a court system that we have, where we can have the court take discretion over the individual circumstances in case. I therefore move this amendment and close.
Okay, thank you. Committee, we have the motion on the floor. It's what you have in front of you. All those in favor say aye.
Aye.
Opposed, no. The noes appear to have it. The noes do have it, so the amendment fails.
Madam Chair, on that particular amendment, I would like for my no vote to be recorded in the minutes.
Okay. We will do that. Thank you.
Thank you.
Anyone else? Okay. Are there any other amendments? Representative Smith.
Thank you, Madam Chair. Well, this is easy. So my amendment, if we can hand that out. You know, one of the issues that I think about on this that I wish I had had an opportunity to have some input on is the idea that you can take an action that the law enforcement agency has done, sit in a courtroom for 2 weeks and discuss how they did it, and then decide, well, it looks like they're paying because the officer made a decision in 2 hours or 20 minutes that the court was allowed then to go over and over. So let's take the argument of clear and convincing versus a preponderance of the evidence. Even during testimony, we heard that this is a sticky wicket, that what one may agree is a preponderance of the evidence, another may believe is clear and convincing evidence. So here I am as a law enforcement officer, and $16,000 in attorney fees is hinged on the idea that the court either agree or disagree with that argument after hours of arguing. I don't think that that is going to have a good effect on law enforcement. It's going to have a chilling effect on law enforcement if they're forced to have that argument and discussion amongst themselves and then hope that the court agrees with them. So on page 18, line 3, asserted in interest, insert, there shall be a rebuttable presumption that the seizing agency shall not be required to pay attorney fees or costs of the claimant associated with the litigation if the court makes a finding that the seizing agency acted in bad faith or knew or should have known that the evidence demonstrating that property is subject to forfeiture did not rise to the level of clear and convincing evidence. The court shall order the seizing agency to pay. Now, the revisor has discussed with me this idea of this concept being in conflict with the word may, and I've asked her if she would explain the idea of that.
Thank you, Madam Chair. The first thing I want to point out, there's a typo actually in that balloon in line 2, required to pay. It should just say attorney fees, not to attorney fees. So you could change the court may order the seizing agency after the rebuttable presumption, but typically the purpose of a rebuttable presumption is to put something in place. There's a presumption that the law enforcement agency is not going to have to pay the fees. And if that presumption is rebutted because of showing a bad faith or that the law enforcement agency should have known that it wasn't clear and convincing evidence, then if you have the court may order the seizing agency to pay, it's completely discretionary. So it kind of defeats the purpose of having the rebuttable presumption in the first place. That's why this amendment would have the shall retained. That's not to say you can't change it to may, but then it's discretionary on the court and there's no real requirement that the rebuttable presumption play out. So, unless you wanted to,
We'll see when you okay, so Representative Smith, do you want to explain some more? Or would you like to move your amendment?
No, I'll move my motion for this amendment.
Okay.
The one I presented.
Yes, very good. Is there a second? Representative Goddard seconds. Okay, discussion committee on this amendment. Representative Osman.
Thank you, Madam Chair. So when we had the Kansas Judicial Council, there were multiple meetings over several months. And the first meeting was basically just parties inside sort of feeling each other out, trying to figure out what was acceptable and what wasn't. And even to the point where they were asking questions of, you know, is civil asset forfeiture even necessary? Is it really a problem in the state of Kansas? And like that was the basic discussion on day one. And by day two, which was about a month or so later, it was Tony Mativi from the KBI who offered up the fee shifting as a compromise, and it was the first one to start the ball rolling on getting things done and putting things down, saying we can find common ground. Now, I'm not saying that everything that happened in the Kansas Judicial Council needs to be what we do here, because we can change whatever we want to, we can do whatever we want to, but I'm just saying it was law enforcement that made the initial first move to say, let us put fee shifting in there. Let us have attorney's fees as a requirement. And so and they stood up as well, saying that they were in support of this bill. So I don't think that while this amendment is reasonable, I don't think that it's necessary to still have the support of law enforcement. And for that reason, I'm going to not be in support of this.
Representative Lewis.
I'd make a couple points. First of all, I appreciate that the Judicial Council worked hard on this, but a lot of us in the committee weren't part of that process. I wasn't, for instance. I don't think Representative Smith was. I think Representative Goddard was. I don't think Representative Titus was, and I could go around the table. Second, the amendment does preserve the idea of fee shifting. So we're not removing that. In fact, we're including the possibility of fee shifting, which wasn't in the civil asset forfeiture bill, the law that we're amending. So in terms of whether attorneys are going to look more favorable at taking these cases, I think even with this amendment, they're going to. And third, it's a point that Representative Mon made with his amendment, and I made at the hearing the other day. I don't think it's good to straitjacket courts. I remember as an assistant U.S. attorney back in the 90s, we were first implementing the sentencing guidelines, and those guidelines were straitjackets, and courts hated it. And quite frankly, prosecutors hated it, defense lawyers hated it. And eventually the Supreme Court intervened and gave discretion to the courts to apply the guidelines as they are guidelines and not straitjackets. And I think generally, and I could also say that there's been a lot of opposition to mandatory minimums over the years for the same reason, that it's treating every case the same, and each case is different. And so for those reasons, I support the amendment.
Any other discussion on the amendment committee? Representative Goddard.
Thank you, Madam Chair. This is more of a technical thing than anything else. In line 2 of the box of the proposed new language, should that TO2 be stricken?
Yes, you're correct. That should be.
All right, thank you, Madam Chair.
Yeah, thank you. Representative Carmichael.
Thank you, Madam Chair. My hope was that I could have remained silent on this bill because it was a carefully crafted delicate compromise to try to resolve an issue which has befuddled and burdened this legislature since I came here 10 years ago. I don't think there's really any substantive difference between Representative Mond's amendment regarding the word may and Representative Smith's construction using a rebuttable presumption. In fact, this language, I would suggest, is a stronger, prohibition is not the right word, but is a stronger test to meet than what we talked about in the First Amendment, because this clearly establishes a presumption that the agency shall not pay attorney's fees. And that was the gravamen of the issue that you heard Director Matavy tell us briefly about in his testimony, that this was part, I wasn't on the committee, but this was part of the discussions that got this off dead center. The snowflake liberals like me are giving up a lot on this, a lot of things that we wanted. And I'll be honest with you, last night, some people in the Senate chewed me up and down because I told them I was going to vote for this. Because there's a lot of things that people who've had their assets seized want to see done beyond this bill. And so everybody gave up a little bit. Now, let me tell you, Director Matavy is no fool. He is an experienced federal prosecutor. He works in the same office, or worked in the same United States Attorney's Office for the District of Kansas, as one of my good friends who does civil asset forfeitures. He understands what was being given up here, because the collective wisdom was the best approach was for everybody to give something up. And if we take away the fee shifting and establish a burden to overcome a presumption of no attorney's fees, then we turn the entire compromise on its head. What we will hear is either no bill that progresses, or the good work of this committee, as reflected by this bill, will lose my support, and I'll go over with the folks from the Senate. So if we want to do something real that has the agreement of Kansas law enforcement, collectively, all of them sat here and signed on, then we shouldn't do this. If we want to continue the quagmire of civil asset forfeiture to continue, with the resulting lack of faith and distrust in Kansas law enforcement by some people who are sadly ill-informed about the facts, and others who might in some instances have grievances, then we'll go back and we'll put this presumption against attorney's fees in. No lawyer with any sense would take what we were told is the majority of the civil asset forfeitures in this state, because, as I recall, they're $750 or less. Without fee shifting, this doesn't work. So I'm opposed to this amendment. Thank you.
Any other? Representative Lewis.
I just respond to the comments. Number one, there is fee shifting in this amendment. Number two, Representative Goddard pointed out that the committee actually said that the court can, which is more consistent with this than the original bill shall. And third, as to law enforcement support, we heard yesterday that law enforcement is divided on this point. We had several law enforcement conferees say they wanted this changed. So on those three points, I just make those.
Committee, are there any other comments? Representative Mon.
Just want to make it clear, while my proposed amendment of shall to may, I still think would be a good idea. I think this amendment might be a step too far. I also want to just recommend or just note that while this bill is not only the product of the Judicial Council's months-long inquiry into this, but also pretty much a day-long committee meeting on this point during the summer, chaired by Representative Owens. And so that this bill, even without the amendment that I recommended, does reflect the consensus of both sides of the floor, and obviously it was a joint committee, so we had a lot of senators on board with the way this came out as well, and I think it's the way to get it done.
Any other comments, committee? Okay, would you like to close on your amendment, Representative?
I would. I'd like to address a couple of things on this. I have the utmost respect for Director Matidi, and I believe that his expertise is unreproachable. I'm going to offer that I'm probably the only member in the legislature right now who's actually taken part in these type of operations, and I've done so in an assistance to drug task force, et cetera. And I understand that there are situations out there, incidents out there that have occurred that have captured headlines. For crap's sake, they're not going to give news reports on things that went well. So that's what we base our decisions on, are those things that went bad. There's corruption in every process. My concern, one question I would have is whether the clear and convincing had replaced preponderance of the evidence before he offered that it was okay to fee shift. But my proposal is because of that very thing that we're talking about, where officers believe they're doing the right thing, and yet they're putting their agency at risk because some lawyers are going to sit back and Monday morning quarterback what they decided and decide, you know what, let's make them pay for this when they're trying to do their job. So I think it has a chilling effect and will have a chilling effect. And I get that this is not a popular idea with this committee, but I assure you it will have a chilling effect for some when their administrator, including myself, are second guessing them out there on the road. So I'm going to move my amendment.
Thank you, committee. You've heard the amendment, the motion to move this amendment. All those in favor say aye. All those opposed, no. But I believe the noes have it. The amendment fails. Okay, so are there any other amendments? Okay, so we're on the bill. Do we have a motion on the bill? Yes. Amendment. Okay, wait just a second. Can you speak in the microphone a little bit? And I will allow you to do that. So go ahead.
I apologize.
It's okay. Yeah.
I'll explain why, but nonetheless, on page 18, where we say the court shall order the seizing agency to pay, the amendment would read, the court, there is a rebuttable presumption that the court shall order the seizing agency to pay.
Okay.
So can I say that again?
Yes, please say it again with exactly where it would go.
It would start after the comma in interest, after interest, comma.
Mm-hmm.
There is a rebuttable presumption that the court, and then pick up, shall order the seizing agency to pay.
Okay, and are you going to move your?
Yes.
I'm going to allow a conceptual amendment, and I think it's the decision. So I'll allow
right. I move my amendment.
Discussion sake. Okay, do we have a second on that amendment? Representative Mon, seconds. Representative Miller, discussion on the amendment.
Yes, and I mean no disrespect, but that language is what I would call an oxymoron. When you say presumption followed by the word shall, I can make no sense of that.
Any other discussion on the amendment? Representative Carmichael.
Thank you, Madam Chair. I'm not going to describe it as an oxymoron, but if I can try to apply the legal analysis to this, is that there is no standard here offered as to what type of evidence would rebut the presumption. In other words, under this amendment, it would be that there is a rebuttable presumption that the court shall order the seizing agency to pay, but it doesn't explain what would be necessary to rebut that presumption. And without that, it becomes, I wouldn't call it an oxymoron, but it becomes what I would consider to be surplusage, because there's no evidence what the court could use. And if the court deviates from the black letter of the law, if this were to be amended, then it's just a matter of the court now applying its discretion to turn what is the word shall into the word may. And we've dealt with that on 2 previous amendments. And so I appreciate the representative's attempt to water down the bill. But this, in my opinion, this is not good drafting, and it doesn't reflect well on the committee to leave that type of an ambiguity. Thank you.
Is there any other discussion on the amendment?
You go first.
Representative Mon.
Thank you, Madam Chair. I second this amendment because it basically does exactly what I wanted to do, changing the shall to may.
Okay, any other discussion? Representative, you may go ahead and close. You may say your, and then go ahead and close on your amendment.
So with respect, I mean, the phrase rebuttable presumption is used in the law all the time. There's no ambiguity about that. And we give courts discretion on these issues all the time. That there's, the idea that this is somehow unusual to the law or giving courts discretion. What this says to the court is you basically have to presume that you're going to order attorney's fees paid, but that presumption can be overcome. And that's a very common idea in the law. There's nothing unusual or ambiguous or vague about this. And so I close.
Thank you. Committee, you've heard the amendment. All those in favor say aye. All those opposed, no. I believe the noes have it. The noes do have it. Thank you. Okay, committee, are there any other amendments? Okay, do we have a motion on the bill? Representative Owens.
Thank you, Madam Chair. I move that we pass out House Bill 2606 favorably.
Second by Representative Mon. Discussion on the bill. Seeing none, Representative, you may close.
Thank you, Madam Chair. I think that it's always good to have debate and discussion as it relates to any type of amendments. And I certainly can appreciate that the only standing member of law enforcement does sit on this committee, and I respect him immensely. Again, having spoke specifically to each one of those members afterwards and understanding where they actually stood on this and why they did what they did, I'm very confident that moving forward, this bill is a great piece of legislation, and I look forward to moving it. So I close.
Thank you. Committee, you've heard the motion to pass House Bill 2606 favorably for passage. All those in favor say aye. Opposed, no. The ayes have it, and House Bill 2606 is passed favorably. Committee,
Madam Chair, would you please record my affirmative vote in the minutes of this meeting?
Yes,
thank you.
Anyone else? Okay. Committee, we are going to go ahead and work House Bill 2599. I know the hour is late, but we're not really going to have a chance to do it tomorrow, so we are going to go ahead and do it today. House Bill 2599. Do we have any amendments? I'm sorry, I said it wrong. Well, it's on the agenda wrong. It's House Bill 2599, and it's the KORA, the Kansas Open Records Act fees. Okay, are there any amendments? Okay, I actually saw Representative Titus first, but sorry. Okay, Representative Titus.
Thank you, Madam Chairman. Natalie, could you pass out the fee amendment first?
Would you like to explain your amendment as you're passing it out?
So in looking at the language that was put into this to try and ease the burden on providing access to public records, we had a good conversation on balancing transparency and access to records and the burden that it can also place on the government agency. So I've put together some guidelines or a fee schedule here in which I've attempted to strike that balance. It also sort of clarifies when fees can be charged. So I just lay it out plainly in the first section there and say no fee shall be charged if the total cost of the records request is $100 or less. So I think on the short end of this, that takes care of the sort of nickel and diming for requests and makes information more available to the public, especially where it has a low cost. The Second Amendment clarifies, there was some discussion about what is an initial search, how is that different than a review? And I've added language to try and clarify that no fees shall be charged for the initial search to determine if there are records responsive to the request. So there's no question whether that involves a review. It's just we're doing a search. It looks like something is responsive. Now you can do a cost estimate instead of deciding where that line is. And then in order to help with the higher end costs, I've kept the language about the fees for review shall not exceed the lowest hourly rate, or it will be capped at $30 per hour. So I think that where you see thousands of dollars of fees in a records request, I think this takes care of issues on the top end, but it also allows for some recovery of fees. So my goal here is to strike that balance between the agency and the transparency needs. So with that, I would move adoption of my amendment.
Thank you. Do we have a second on the amendment? Representative Neely seconds. Committee, do you have any questions on the amendment? I'm giving you just a minute to look at it. Okay, committee, are there any questions for Representative Titus on his amendment? Representative Osman.
Thank you, Madam Chair. I'm just wondering, with regards to $30 per hour, whichever is less, how did you arrive at that?
I think that lands you somewhere in the average hourly rate of a staff attorney or for a state employee. Once you get higher than that, you're talking probably chief counsel review, deputy secretary review. And so that felt like too much for a reasonable amount for transparency's sake.
Any other questions? Okay, Representative, you may close on your amendment. I'm sorry, Representative Carmichael.
Thank you. If I might inquire, I don't think that this amendment touches the scope of the overall bill, which I think was limited to executive branch agencies. Is that right? It doesn't change whether municipalities or others?
That's correct. I do have a second amendment that would deal with that, but that is not
That-
included in this.
Okay, and second, to make sure I'm not getting things confused here, there was also discussion that we could in fact charge out-of-state request stores, and this doesn't address that either, does it?
That's correct.
Okay, thank you for the clarification.
Okay, committee, any other questions? Okay, Representative, you may close on your amendment.
I close.
Okay, committee, you've heard the motion to accept this amendment. All those in favor say aye. Opposed, no. Okay, the amendment passes. Just 1 second. Oh, I wasn't on the. Okay, I'm going to go ahead and call on Representative Titus for your amendment.
Thank you, Madam Chair. Natalie, if you could pass out the second one. So as Representative Carmichael previewed, this amendment then would expand the scope of this section of the bill. It's my belief that while I have the perspective of being in an agency and reviewing records, the ultimate goal of this is transparency. Every government entity that is taxpayer funded in this state has an obligation to provide information to the public. So my second amendment would propose that the fee schedule we just adopted also apply to all municipal governments or as public agencies are defined in the act. So that's basically every city, county, board, et cetera. And that's the large bubble you see there. However, understanding that does increase, there are many small things that municipalities are charging for that they would no longer charge for. In order to balance that, I've added language that allows, if you are not a resident of the state of Kansas or an entity registered with the Secretary of State to conduct business in Kansas, then you can be charged the full cost of procuring those records requests. So I would move my amendment.
Okay, do we have a second? Representative Miller, second. Okay, discussion on this amendment, committee. Representative Osman.
Thank you, Madam Chair. On subsection D, should it be if the person making a request for records does not reside in the state of Kansas or is not registered with the Secretary of State?
Thank you, Madam Chair. You might have been able to notice from the discussion today, I got a lot of amendment requests pretty last minute. Yes, so that should be is not registered with the Secretary of State.
Any other discussion, committee, on this amendment? Yes. Representative Carmichael.
Thank you. Two clarifying questions. You talked about municipalities, which includes counties and cities. Would it also include Board of Regents institutions, the hospital board, etc.? I mean, for purposes of the Tort Claims Act, I think they are quote unquote municipalities, but I want to make sure we're clear that what we're reaching.
There we go. Thank you, Representative Carmichael. KSA 45-217 defines a public agency as any state or political taxing subdivision of the state or any office, agency, or instrumentality thereof, or any other entity receiving or extending and supporting in whole or in part by the public funds appropriated by the state or by public funds of any political or taxing subdivision of the state. So yes.
And then secondarily, how does this relate to the courts, if at all, and or the legislature itself?
They retain their ability to set their own fee schedules.
Thank you.
Any other questions on this amendment? With that, Representative, you may close.
I close.
Committee, you've heard the, or you've seen the amendment. All in favor say aye. Opposed, no. The amendment passes. Okay. Okay, we have another amendment. Representative Osman. Would you like to explain your amendment?
Yes. Do I need to make a motion for the amendment? I'm not sure. So
You can explain and make a motion, or you can either way.
All right. Thank you, Madam Chair. This is what I consider to be a language change, but I don't believe it's a functionality change in terms of what this bill is designed to do. It is on subsection 2 on page 2, or II. For the cost of employee time required, instead of to make records available, it's to provide access to or furnish copies of public records. And I had some conversation with one of the opponents who basically said, look, we understand that the issue for us is just that there may be a judge that makes a determination that just the availability is the only thing you would be compensated for, as opposed to the review time, as opposed to the redaction time. And so this provide access to or furnish copies of public records would just clarify that particular statement, as opposed to just making records available. And the other argument that they were presenting to me is that make records available itself is not referenced anywhere else in this bill or anywhere else within the statute, but to provide access or to furnish copies of public records was the language that was used, I believe, in Senate Bill 284 from 2022, when they tried to do a very similar piece of legislation through the Senate. I don't have that up in front of me, but basically that is the language that they tried to use. And so all this is trying to do is just clarify that the review process will include all parts of the review rather than a singular part of the review. If, and I believe that's what the committee is intending to do in the first place. If that is not, then that's a separate discussion. But I think this is just a clarifying issue.
Okay, thank you. Would you like to move your amendment?
Thank you, Madam Chair. I move my amendment.
Do we have a second? Representative Curtis, second.
Surprise, surprise. There's a typo in this amendment. In line 17, it's required 2, so I didn't need to start the balloon with 2, so scratch that.
I make a motion on my amendment as amended.
Is that okay by the second? Yes, okay. All right, Representative Lewis has a question.
Yeah, so I'm just a little, I think I agree with you. I just am not exactly clear what we're doing here. So we're saying that they can charge the cost of employee time to provide access or furnish copies of public records. That's your amendment. And then how do you reconcile that with B, which no fee shall be charged for a search to determine whether requested records exist, or for any employer administrator review of the records? Or we're still okay. I'll just stop there.
Thank you. No, this is a good question. It is not. Okay, so this is the same way to provide access or furnish copies of public records. So it includes the entirety of the furnishing, which includes redaction. That is their main concern, is that there are multiple documents that may need to be redacted, and that is going to take time to do. And they just want to make sure that in this language, it calls for that as part of it, not necessarily just the search itself. That so it's not conflicting necessarily with the search beforehand. It's the redaction afterwards.
Representative Titus.
I just know, Representative Lewis, that in the First Amendment, we did clarify that initial search as being sort of a separate search about just to determine the existence of relevant records. So that should help with any confusion.
Thank you for that.
Representative Goddard.
Thank you, Madam Chair. In your amendment, should it not be expanded to jive with Representative Titus's amendment that would say a fee shall not exceed the lowest hourly rate of an employee qualified to supply the records, or $30, whichever is less?
Thank you for your question. As I see it, it shouldn't conflict with that, because it's just changing these three words that are in here to pull in this phrase. So everything else under the previous two amendments that we passed shouldn't conflict with that, but I would ask the reviser if that's an issue.
Thank you, Madam Chair. The words of these two amendments do not conflict. If you think there's a conflict policy-wise, that's up to you guys to make. But the two amendments could be added to the bill, and there would be no issues with that.
So we're assuming that it would never exceed $30 an hour.
Representative Titus.
We've said that it won't. I don't think it matters. I think the two amendments work together, and I actually think Representative Osman's change of language here is a welcome modernization of some out-of-date terminology.
So if you look at the section, Representative Osman's amendment is little I, and then Representative Titus's amendment that we passed begins with B and C. So they don't do this; they're separate. Okay, committee, any other questions on the amendment? Okay, Representative, you may close.
I close and move my amendment.
Committee, you've heard the amendment. All those in favor say aye.
Aye.
Opposed, no. Okay, the amendment passes. We passed 3 amendments on this bill, I believe. And so now we're on the bill. Do we have a motion on the bill? Representative Titus.
Madam Chair, I move that we pass HB 2599 as amended favorably.
Second by Representative Mon. Committee, any discussion on the bill as amended? Okay, so I don't believe there's any discussion. So with that, all those in favor of passing House Bill 2599 out as amended, say aye.
Aye.
Opposed, no. House Bill 2599 is passed out favorably for passage. And yes, Representative Carmichael.
I'd like to have my affirmative vote on this excellent legislation recorded in the minutes of this fine meeting, Madam Chair. Thank you.
Committee, I really appreciate your hard work, especially Natalie, for getting all this done. We thank you so much. We have the best, I believe. Okay, everyone, have a good Valentine's Day, and thank you. Tomorrow, I think, will be a full day. We will not be working any bills tomorrow. We'll just be hearing